Episode 31.
Hey, this is John Lee Dumas of EO Fire, and you're listening to the Small Business Puzzle Podcast. You must be prepared to ignite.
Struggling to get your business online? You've come to the right place. Welcome to the Small Business Puzzle Podcast. Now, here's your hosts, Michael and Teresa Blaze.
Welcome to the Small Business Puzzle Podcast. I'm Michael, and I'm here with my better half and my wife, Teresa.
Hello, everybody.
We have some amazing news for you guys. We are absolutely blown away by this.
Yeah, this is huge.
We have been invited to speak at Podcast Movement this summer in Anaheim, California.
If you're going to Podcast Movement, we can't wait to see you there. We'd like to know about it. But if you're not, well, we may have just given you an incentive to go.
Yeah, you get to meet the two blind marketers in person. How much better can you get? And to find out more about the Podcast Movement, you can go to podcastmovement.com.
Yeah, go there, check it out. It's a cool thing. So, that being said, Michael, any other announcements?
Nope, that's all the announcements. And we do have a guest today. We decided to go a little different route than normal. And we have a gentleman that is an internet lawyer.
Internet lawyer?
Yes.
That's like deciding whether the internet is legal, right?
More like trying to protect people from stupid government morons that want to control everything.
Oh, okay. No, seriously, guys. Whether you do everything right and you get your conversions right and you have everything set up on your website, if you don't have your legal documents in place in the way they need to be, you're opening yourself up for trouble.
I'd like to tell you a little bit about Richard. His name is Richard Chapo. He's been a lawyer for 24 years. He is a well-known internet business lawyer in Southern California. Richard's philosophy is to proactively position his clients to minimize their personal exposure to lawsuits. To do this, he provides advice to clients such as large multinational corporations and as small as hobby bloggers with an eye towards eliminating potential problem areas before lawsuits are filed. Richard is versed in a variety of internet laws, including the DMCA, Communications Decency Act, and the Child Online Privacy Protection Act, as well as FTC compliance guidelines, state privacy mandates, and recurring billing laws, among other things. And while it's a mouthful, Richard is really good about dropping things down and making things understandable. It was a very eye-opening conversation.
Yes, it was. So, without further ado, here's Richard. Hey, Richard, wanted to say thank you for joining us on the show today.
Well, thank you for having me.
So, we actually got a hold of you as someone who deals in internet law, and you actually approached us with a specific topic. Do you mind explaining what that is?
Sure. Yes. Yes, I do specialize in internet law. I work with small internet businesses. And one of the things that's happened recently is a change that your listeners can implement with their websites or their apps or, frankly, any business that can really limit the potential of being sued, or if they are sued, really limit the possibility of having a bad judgment returned. And it has to do with arbitration. Arbitration is essentially like the trial that you'll see on TV and courtroom dramas, except it's done informally. It's not in front of a jury. It's done in an office somewhere. And the arbitrator is typically either a retired judge or an attorney that the parties agree upon. And the rules for processing the dispute are a little simpler. In general, businesses prefer to go to arbitration, while consumers prefer to go to a jury trial. And the reason for that is in an arbitration, because the arbitrators are retired judges or attorneys, they tend to understand technical arguments a bit better, and they also tend to issue smaller awards, damage awards, monetary awards, if they do find you liable for something. With the case with the jury, juries can be inflamed, and when they get inflamed emotionally, they can return large rewards. So the classic case that a lot of people know about was the McDonald's hot coffee case. This was a case a few years ago where a woman went through, I believe she went through the drive-thru. She ordered a hot coffee. They gave her the coffee. She put it between her legs. It spilled and it burned her. And she sued McDonald's, and the jury returned a verdict of $2.9 million. And this was a bit surprising to people because before the case had gone to trial, there was a belief that McDonald's had offered to settle. They'd offered to pay her medical bills and then settle for $800 for pain and suffering, while apparently her attorney had demanded $20,000 to settle the case. So if those numbers are true, you kind of have an idea of what the attorneys valued the case at least certainly the range. So the $2.9 million figure was a little shocking. And it went out in the media and all over social media as, look at this crazy jury. Now, in their defense, I will tell you, it wasn't hot coffee. It was scalding hot coffee. The person who set up the coffee and brewed it had done it incorrectly. So when she put it between her legs, it was actually, boiling hot. And she did suffer burns. She was hospitalized. It was, a fairly serious case. So it wasn't completely out of line. On appeal, they dropped the judgment down to, I want to say, like $400,000. But that was a jury's reaction to seeing those pictures of the burns and what have you. If that case had gone to an arbitration instead, McDonald's definitely would have been found liable, but the arbitrator probably would have awarded just whatever the plaintiff asked for, which probably would have been $20,000 or $50,000, whatever the number was. So you can see kind of the difference as to the potential outcomes. For your listeners, consumer arbitration, which is what this is called, is very important, and it's something that you should take advantage of. In the terms and conditions of your website or your app, you should have a clause in there that basically requires any of your users to agree to arbitration, mandatory arbitration. It's called mandatory arbitration and class action waiver. And this is important because what it does is it protects you. In many cases, it eliminates potential lawsuits against you, and even if they occur, again, it keeps the damages low. And here's why. Think about internet transactions. How much money do you spend on the average internet transaction? With Amazon, maybe $70, $80. We're not talking about thousands and thousands of dollars in most cases. I mean, obviously, there's some transactions like that. So if a dispute arises, typically what one of your customers will do is, perhaps try a chargeback where they complain to their credit card company and try and get the money back through that, something of that sort. Typically, lawsuits don't arise. There's just not enough money involved.
Right.
So what happens instead is class action lawsuits are put together to try to overcome that problem. So let's use an example. Zappos. Zappos is a huge retailer online. 3 or 4 years ago, they were hacked, and a bunch of their customer data was copied, and it started appearing on Ukrainian servers and all over the world. Kind of a disaster. They didn't have an arbitration agreement that was binding on their customers, and so what happened was, people were saying, well, what are the damages associated with that? What monetary figure can you apply to that? And whatever the figure was going to be, it was going to be fairly small. So a class action lawsuit was filed. And what a class action lawsuit is it says, okay, we have an action against a party, in this case Zappos, that is all based on the same claim, that they were hacked and they should have had better security. And all these different people are making the same claim. So instead of having 10,000 different lawsuits, we're going to have one lawsuit and put them all together.
Right.
And so when they make the pursuit, the damage claim, instead of it being $5,000 or $10,000, because you have the 10,000 plaintiffs, the damage claim is many, many millions of dollars. And so class action lawsuits can be lucrative. They bring in a better quality of attorney, frankly, and they can really sink businesses. Now, by putting putting a mandatory arbitration and class action waiver clause in your terms and conditions, you can prevent consumers from doing that. And the interesting thing about all of that is that if we go back in time, it all comes to 2011, way back in time in internet terms. Before 2011, states were allowed to pass laws on arbitration and enforce them. And so, like a state like California, for instance, enacted a law that said that companies could not use these arbitration agreements. What happened in 2011 was, at that point, we had a fairly solid conservative majority on the Supreme Court. They had switched over from a liberal majority. And they took up a case called AT&T Mobility versus Concepcion. And in that case, AT&T Mobility was selling smartphone plans, access plans, and they had an arbitration clause in their agreement, and a class action lawsuit was filed against them. And they argued that the arbitration agreement should be binding. And all the way up through the court system, they lost a trial, they lost an appeal, eventually got to the Supreme Court. And the conservative justices issued a ruling that overturned literally 100 years of law. And what they said was that the Federal Arbitration Act of 1925 preempts state law, meaning that if there's a federal law on an issue and the states have a similar law, the federal law is almost always going to be found to be the binding law. And under that law, the companies could, in fact, go ahead and issue these arbitration clauses and the class action waiver clauses as well. So this is obviously good news. Now, Zappos, if we go back to Zappos, if Zappos had done that and instituted it correctly, they wouldn't have faced a class action arbitration. What they would have faced was a bunch of small claims court actions. And in those, if you think maybe we use the number 10,000, let's say there were 10,000 plaintiffs, how many of those plaintiffs actually would have gone ahead and sued Zappos?
Probably not a lot, not as many at all.
Yeah, very few.
They probably would have seen it as not worth anything.
Exactly. With a class action lawsuit, typically they send you something in the mail. You were a customer of Zappos, between these years, sign here and you're part of the class action waiver. And then they'll eventually send you a small check from a settlement. The energy required to do that is much different than, going down and actually suing somebody.
Now, do these arbitration laws, do they count whether you are a corporate company or a self-employed?
No, they apply across the board.
Okay.
It really depends, on the language that you use in the agreement. But yeah, you can do them. We're talking about the online situation now. You can do them in business-to-business agreements. If you were to hire a consultant for something, you'll almost always include an arbitration clause. But the problem in the past has been doing them with consumers has been difficult. So once Concepcion, AT&T Mobility versus Concepcion passed, you actually saw a lot of these companies come forward and start issuing or amending their terms and conditions and adding these clauses, and there was blowback on social media. eBay did it, PayPal, pretty much any large company started doing it. The thing for your listeners to understand is that you don't have to be a large company to do this. It's literally maybe a page of language, and it's boilerplate and stuff that you probably hate about contracts, but it's important. It's very, very important. And the thing that frustrates me as an internet lawyer is I have people come to me and they have litigation problems because they didn't do their terms of use right. The terms and conditions are also called terms of service. People don't understand in small business, those are not there for your visitors. They're there to protect you, the business person. It's like buying insurance for your business. So you really want to do those correctly. So having that clause is, very, very important.
Well, aside from the arbitration clause, I cannot talk today. Arbitration clause.
Excuse me. Sorry about that.
Not a problem. Aside from that, what else should a business owner or a podcaster or whoever include within their terms of conditions and or terms of use and all the other legal documents that we know about but hardly ever read?
Right. Well, with terms and conditions, it depends a little bit on the site. Depends on, are you offering a membership? Are you selling a product? Or is it just a blog? It kind of depends on that. But the key provisions are typically you're going to want the arbitration and class action waiver clauses. You're going to want something called a choice of forum clause. So what a choice of forum clause does is it sets the location where any legal dispute would be heard. So, for instance, if you are in California, let's say your business was in California, and you have a customer in New York who's unhappy with something and they want to sue you, well, where does the lawsuit happen? Or where does the arbitration happen?
It would have to happen in the state where you're
right.
incorporated.
So with the choice of forum clause, you're going to designate it as not only your state, but your county. And so they have to come to you. Now, choice of forum clauses, some attorneys will tell you they're slam dunks. They're not. They'll be enforced maybe 75% of the time. a court is going to look at whether they're fair to enforce.
Right.
But but you still want them because at least it gives you leverage. And Google has been able to force users across the U.S. to come to California to litigate against them, because of this clause. So it is an important clause. Other clauses that are also important, will deal with intellectual property. Depending on if you allow users to post anything to your site or to your app, you want to be compliant with something called the Digital Millennium Copyright Act. It's the DMCA, better known as.
Oh, yes, we know that one too well.
Right. That's very important. The reason that's important is because so long as you comply with the compliance process called out in the law, you cannot be held liable for copyright infringement based on whatever your users post. So a real-world example would be Facebook. As we were chatting before this interview, Facebook doesn't really produce any content. Instead, it just lets its users produce all the content. Well, there's no way that Facebook can monitor, all billion accounts to determine if people are posting, images or songs or whatever that violate the copyright of somebody else.
Right.
So they sit behind the DMCA, and what happens with the DMCA is a copyright owner has to file a complaint with the site to the DMCA agent that'll be listed on the site. That agent will then look at the complaint, see if it meets the requirements of the statute, and if it does, then they automatically take down the contested content. And they send a notice out to the person who posted it saying, hey, this party is saying that you're infringing on their copyright. You need to respond or what have you. At that point, in 99% of cases, the person doesn't respond because they realize, I didn't realize that. And they're hoping they're not going to get sued, and that's just the end of it. And the content stays down. If they do file a counter, good Lord, like the communication man today. If they do file a counter notice, they can claim, well, it's not infringement, and here are the reasons. At that point, Facebook would then let the copyright owner know, that this party is contesting it, and at that point, those two parties would go off to court, and then they would have a debate about, whether it was infringement or not. But the key thing is Facebook would not be dragged into that litigation.
Right.
And again, this applies to any company. You don't have to be as big as Facebook. That a tiny blog can take advantage of this. And the compliance costs, literally, as an attorney, of course, I want you to use an attorney, but there is a book on Amazon called the DMCA Handbook. I think it's $40. It was written by an attorney in Arizona. It lays out the process for compliance, and it also contains template email messages to send if a complaint comes in. So basically it takes care of it if your listeners are comfortable with doing it yourself approaches. So the DMCA is very important. And there are other laws. It just kind of depends on the nature of your site.
Okay. Well, I've heard of situations where, like on YouTube, two people will upload the video, but they end up taking down because they've got some kind of copy software where they're monitoring for copies of videos, if I understand it right.
Yes.
And unfortunately, the original video sometimes ends up getting taken down, even though it's their video.
Yes. So YouTube's a little bit different. The problem that YouTube had was that they were getting sued by the big content publishers, and they entered into agreements with some of these groups. And so that they've kind of moved beyond the DMCA. They have their own little system, and that system is a software system that is filtering various factors to determine if a video is violating somebody's copyright, or if it conflicts with something that's already on a list of protected properties. And they do have problems with it. It's, sometimes they'll take down something like the original video instead of the copy. Those instances do arise. It's not surprising. Consider Google received, I think it was 8 million DMCA takedowns last year. You're talking about a large volume of complaints, so there are going to be mistakes. There just are. And that does happen. But YouTube uses its own screening system. It has a whole software system set up to try to deal with it. And there are going to be problems with that. As far as a small business owner, if you post a YouTube video and it does get taken down and you want to contest it, then certainly that's something you go through their system and try and use. Apple has an informal system for dealing with these issues as well. If somebody reproduces your book and puts it up as an app on iTunes or something of that sort, Apple has a pretty good system. The only problem with Apple's system is it's slow. I have a client, we just did it. It took 2 months to get it down.
Oh, wow.
Yeah, and as aggravating as that was, though, it was still less expensive than going to litigation. The problem with going ahead and suing that party was, based on everything we could find out about the party that had posted it, they didn't have any money. So we were going to spend a large amount of time getting the video taken down and get nothing back. And as much as, I enjoy attorney's fees, the client wasn't, as excited about paying those. So with some of the larger companies, there are definitely informal systems that they put together to address with these issues. And, generally you want to try those first because you can, a lot of times you can get it taken care of, and it doesn't, you don't end up paying a lot of legal fees and what have you.
So the question regarding getting back to this arbitration thing, most of our listeners are not going to be Zappos and eBay and those kind of companies, with deep pockets. Like McDonald's has very, very deep pockets.
Sure.
Why would it be important for it to be included for someone who doesn't have deep pockets?
Right.
A small business owner.
Well, it's important because in a lot of cases, if somebody was going to come after you, this will prevent litigation.
Okay.
So if you think about it, if you have your choice of forum clause, so they have to travel across the country, and they're looking at an arbitration instead of a jury trial, and the charge that they're contesting is for $60. What is the chance that they're really going to follow through on that? Now, could they have?
Probably not much at all.
Right. And this is, it's a small change. It's one that's, it's kind of like changing the oil in your car, as annoying as that is. If you do change it and you maintain your car, you're going to prevent, more costly, painful repairs down the line. And that's really what this is about. It don't have to be a big company. I use the big company examples because everybody knows them.
Right, right.
But certainly anybody that is selling something, whether it be a membership, a product, a service, can use this. With blogs are a little bit different. The problem with a blog, the problem with the internet is there's a really basic legal question that's floated around for about 15 years. And the question is simply this. Should somebody who visits a website be bound by the terms and conditions of that website, and when? And when, if we're looking back to 2000 or so, when the internet started getting rolling as a commercial medium, most of the judges had never been on the internet, didn't know much about it. And so they would issue kind of strange rulings and say, yes, they should be. And so people would create terms and conditions, and they would put a link in the footer of the site. Mm-hmm. Now, you two obviously use the web, frequently, and I'm sure your listeners do, and I do. When was the last time you ever scrolled down to the bottom of the site, clicked the terms and conditions link, and read that document?
Almost never.
Never?
Yes, exactly. Well, as time has passed, judges have become more savvy, and they've realized they never do that either. And so attorneys have argued that approach is called a browser app agreement, and it was typically used with software and other products, and it was kind of melded onto the web. Well, now judges will not enforce those. They very, very rarely will they enforce those. Instead, what they want to see is what's called a click wrap agreement. And, I'm sure you've been on a site at one point where you're making a purchase for something and they make you check a box that says, yes, I agree to the terms and conditions and privacy policy. When you do that, that is the equivalent of a signature on a contract. And at that, right.
Very interesting.
Yes. So at that point, you become bound by the terms and conditions and the privacy policy, unless there's some egregious problem with those documents. But yeah, that is something a lot of people don't understand as small businesses. It is incredibly important that if you have an opportunity, to force your visitors to check that box, meaning, they're registering for something, they're buying something, do it. It is incredibly important. And that's
of a plugin that would accomplish that? I've never seen a.
I don't do design work, but my understanding is there are quite a few free plugins and free scripts floating around the web that people can use. It's all open source, and that you can implement with that. I'm sure there's WordPress plugins. In fact, I know.
We'll try to include a link to a couple in the show notes.
So if I am understanding you right, just scanning the web, reading articles, does not bind you to the current terms and conditions. It is only when you actually take some action like clicking and checking the box that you actually become then accountable to those terms and conditions upon the site.
Correct. There's one exception to that. It's called constructive notice. And the idea behind constructive notice, so let's consider a blog. With a blog, there's really no opportunity to have the visitors check a box agreeing to anything because they're just browsing through the document. There isn't any affirmative step they have to take. They're not registering for anything or what have you.
Right.
So the question then was, well, do terms and conditions apply in that case? And most attorneys would argue no, and I would be one of those attorneys. However, there are two issues with that make it less of a problem. The first is, if you have a blog of that type, what would they ever really sue you for?
Right.
You don't have a product or something that's going to fail. The only thing they could really go after you for is giving bad advice.
Copyright infringement.
Right, copyright infringement, or perhaps libel, something like that. The terms and conditions aren't really going to protect you from those claims, anyways. They could to an extent, but your risk level is fairly low unless you're doing something very aggressive. And the second issue with that is there is a theory called constructive notice that basically what the courts have tried to put together is a rule that says, well, if you can show that the reader actually had notice of the terms, had constructive notice, then we'll enforce it. Well, how do you do that? Well, the best answer is to have a pop-up when they come to the site. They look at the site, and then they have to click it, and that's it. Click it. Okay, I read this, or something like that. And that is something that you probably notice no blogs have. They just don't.
No.
And the reason for that is, who's going to do that? Everybody just hits the back button. And if they hit the back button, not only do you not have a reader, but you also run into a situation where people are you're likely going to be hurting the search engines. Google is going to look at bounce rates and things like that. And if they see people come to your site for a second and bounce off, they're going to think you have a low quality site. So there are all kinds of issues. So very few people. I'm sorry?
It would definitely affect the quality score.
Right. So almost nobody uses that approach, and with blogs, you just kind of have to grin and bear it, in my opinion. But kind of is what it is. The other thing that you have to have in the U.S. Is a privacy policy. The federal government doesn't really require them. The FTC likes to see one, but certain states have passed laws. And the states say that if you have a reader or a visitor that you're collecting personal information from who is in our state, then you have to comply with our laws. And so you do need a privacy policy. If you have European traffic, that area is all changing as well. There's a new general private regulation coming out in 2018 that companies are going to have to comply with, big and small. But they're still issuing guidance on how exactly those rules are going to work.
And Richard, how much does it cost? Let's say a client comes to you. Maybe they've got an e-commerce store. Let's use that for the sake of discussion.
Right.
And they come to you and they say, Richard, I need these documents compiled, and so I can put them on my website. How much would it cost them on average to have an attorney like you put those documents together for them? Right.
It's going to depend on the site. If it's something that's pretty simple, you're probably looking at, I don't know, it could be as low as, $500. I mean, if it was just a blog, because, with a blog, I would put together a privacy policy. I would also put together terms, even though they wouldn't be binding necessarily on the visitors. I still like to put in terms just because it creates some leverage if there was ever a dispute. More complex sites, can be, I would say an average range would probably be in the, I don't know, it's hard to say, maybe $1,500 range. And you can have really complex sites that go much higher. In my practice, I realize that, smaller businesses, they don't really have the cash flow to deal with that, or they don't want to. So I offer payment plans, and I'll stretch things out over, a number of different months to make it more palatable. It depends on the attorney. So my view from my practice is I don't really try to pick up and drop clients right away. What I prefer is to try to build a long-term relationship with clients. So most of my clients have been with me for years. So I'm pretty flexible on payments. Other attorneys, they would want their money up front, and that's, so they're not going to offer payment plans or what have you. It just kind of depends. But some sites are really complex. You can have sites where there's a membership, where they're selling products, where they're selling personal services, and where they're selling something that is a customizable good. And that raises issues ranging from copyright to 30-day FTC merchandise refund laws, because with customized products, you don't have to offer a refund, because think about a painting that a painter has created specifically. It's a one-off type of product, and they don't have to issue refunds. The problem with that is you have to be very careful with what you write in the terms, because most people who are making the purchase don't understand that. And then they come back, and if they want to refund it, it turns into this big brouhaha. And you can get that with custom furniture, custom anything custom.
Right.
So it depends on how complex everything is. But if it's not too complex, it can be as low as $500-$600.
So what you're saying is if you provide it now, is that the same if you offer a custom service?
It would depend on the service. You'd have to look at it, but typically not, because you could argue all services are custom services to some extent. But again, it would depend. It also depends on the professions. In some states, particular professions are very limited. So as an attorney, for instance, in California limits what I can do from a marketing perspective, what I can do from a service perspective, what I can call myself.
Right.
There's all kinds of rules. And California, in particular, is very broad. I mean, they even have rules for people who do, eyebrow tattoos, and there's a law for everything out here, I swear. But in other states, it may be more, more open to interpretation, and there may be different things that you can do.
Now, is it obviously okay? I appreciate the fact that you being an attorney, and you need to make a living and put food on your table, etc. And I know a lot of people that maybe they're just getting started in this. Can they use boilerplate? Like, we use a plugin called WP Fresh Start, and what it does is basically when I install the plugin, I check a bunch of boxes, and I create my terms page, I create my privacy page, etc. And I hit one button, and it creates the pages and puts all the boilerplate copy, and then all I have to do is go in and edit it. Is that an effective way to get it started?
Well, obviously it depends on the quality of what they're producing. I'm not familiar with that plugin, and I'm not hugely happy with most of those documents. The problem being that those documents treat the United States as one jurisdiction for law, but the law is different in each state.
Okay, so you have to have something that involves, or that includes the state where you're operating and running your business from. Right,
and so I've seen a few privacy policies that, quite frankly, were pretty good. I don't remember who produced them, but I've seen other ones that were, if the California Attorney General, for instance, or New York Attorney General, two very active prosecuting offices, saw those, they would go after those companies, and these were small companies, because they were just blatantly violated the law. The other thing is the general documents often don't take into account specific laws detailed to a specific audience. So let me give you an example. Children's Online Privacy Protection Act, better known as COPPA. It's a federal law in the United States, and it says that if you collect personal information from a child under 13 online, you have to first get verified parental consent from the parent.
Right.
Okay, well, you can go on to iTunes, and you can look at, maybe the top 100 games that are clearly directed towards kids, and they're all using these boilerplate privacy policies and terms and conditions, and none of them are compliant. Not one.
Interesting.
And the enforcement damage claims from the FTC start at up to $40,000 per child.
Ow.
Wow.
Ow.
Yes.
Talk about an accident ready to happen. Wow.
No kidding.
Right. So, for instance, Yelp. Consider Yelp. Yelp is a company that is very controversial from a legal perspective. What Yelp does, obviously, you know what Yelp does. Yelp is reviews. Some companies who get negative reviews are very unhappy, as you might imagine, and so they attack Yelp and they say, take those reviews down. And Yelp says, no. There's this law called Section 230 of the Communication Decency Act that says that basically sites don't have to do that. That's how review sites stay online. And then these companies will say, well, you know, we want you to give us, you know, the name of the person who actually wrote the comment so we can sue them. And Yelp will say no, and you have these big fights.
Right.
Yelp almost always wins. They're considered to be both very aggressive and very successful. They have excellent legal counsel and what have you. It's very hard to win against Yelp. Yelp had an app that had an age gateway on it, and the age gateway said, when you signed up, said click a box saying you're 13 or older.
Right.
You know, to try to get around the COPPA provisions. And their app had a software fault, and so you could check, and you cannot check the box. You could say I'm 6 or whatever, and it would still let you in. Now, this is a site clearly not directed at kids, but it was still a problem, and the FTC went after Yelp, and Yelp didn't even try and fight it, and they paid $400,000 to settle it.
Ow.
Wow.
And this is a company that wins almost all lawsuits against it. So that's, you know, the Children's Online Privacy Protection Act. And you look at sites that are directed at kids, and, you know, and they have these, you know, boilerplate terms or whatever. And, you know, frankly, a lot of people just copy them from another site. I had a client call me once, not a client, but a lead call me once that, you know, they were in one state in the South. I'm in California, and they were being, you know, brought into litigation in North Dakota because they had copied the terms from some site that set the choice of forum as North Dakota.
Wow.
So you see, you know, it's terms and conditions and privacy policies. Unfortunately, we're just past the time when you could have a general statement. Now, if it was 2003, yeah, you could probably use just boilerplate language because most of the law hadn't been developed, and states, you know, weren't passing these laws.
Well, it almost seems like as well that, you know, we're entering a time where courts are actually having to address these laws. These are not like, this is not like your basic civil lawsuit. Oh, so-and-so hurt me, so I'm going to sue for damages, or, you know, criminal lawsuit. This is, I mean, and especially when you've got technology that's moving at such a fast rate.
Correct.
You know, it almost seems to me that the law is having a real hard time keeping up. I mean, I follow the news a lot, and it just, you know, it just seems like the law is having a hard time keeping up.
It is. It's having a very, very difficult time. You know, you look at the whole Apple encrypted phone issue.
Oh, don't even get me started on that one.
You know, there are these different areas where there really is no law. And the problem that the government has is, you know, they want access to all of this data, but they're actually violating their own laws. If you did, as an individual, what the U.S. government does in accessing data, you would be in jail. It's called hacking. And you would be going to jail for violation of the Computer Fraud Abuse Act. You know, so it's the problem that we've had in the problem we've had.
CIA and NSA do that all the time.
Oh yeah, no. Everybody does. And the interesting thing is, there's actually a world war going on right now that nobody knows about, and it's over the most bizarre foundational issue, which is privacy. In the United States, we don't really have privacy. From a practical standpoint, the states have privacy laws, but the federal government really doesn't. In other countries and other groups, the EU, for instance, they highly value privacy. And so one of the problems that we're seeing right now is the EU has laws that and regulations that require strict privacy compliance. And they're saying to U.S. companies, you can't move this data to the U.S., because if you do, the NSA and these groups can just go in and copy it all, and that violates our privacy laws.
Interesting.
Right. And so in 2018, there's a new general data protection regulation coming out in the EU, which makes it even stricter. And it contains provisions that are mind-boggling. So, for example, Article 8 of the new GDPR is like the Children's Online Privacy Protection Act I was talking about. except it sets the age at under 16, not under 13. So think about Facebook right now. How many 15-year-olds in Europe do you think are on Facebook? And how's Facebook going to identify those kids? And how's it going to get verified parental consent from each of the parents? It's potentially difficult to see how compliance can even occur.
Wow.
Yeah. Now the member states can drop that age to under 13. They have a choice, but all 28 of them, not all of them are going to do it. So it's going to be a bit of chaos. In France, they can issue fines, or in theory, you could be jailed for a year if you post pictures of your kids on user-generated sites like Facebook if they're under 18.
Wait, back up. So if I'm a parent and I post a picture of my kid, I can go to jail for that in France?
For up to a year. Yeah, you're not going to go to jail, unless it was a egregious case, but you could be fined. And the reason is it violates the privacy rights of your child.
Wow.
Unbelievable.
It's a crazy world that we're living in.
Yes.
Yeah, no kidding. Okay. There is such a thing as privacy laws, but at the same time, you're kind of going, wait a minute.
Right. Well, what it is it's a fundamental difference in viewpoints on these issues. You were saying the law's behind the times, and you're absolutely right. One of the problems of bringing the law current is, well, whose law? Who are you going to comply with? LinkedIn, last I checked, isn't available in Russia, for instance, because Russia passed a law that said if you collect information from Russian citizens, you have to maintain servers here in the country with those citizens' information on it.
Wow.
And Google and Yahoo and everybody else said, okay, and LinkedIn said no. So you can't view LinkedIn there. In Spain, I believe Google News doesn't appear because they consider it copyright infringement.
Interesting.
So the World Wide Web is kind of being partitioned. I'm not trying to scare your users or your listeners at all. It's just that, there are these things out there that are being worked out. And in most cases, the companies that would be sued for these bigger issues are going to be the Facebooks of the world, not little guys.
Right.
But it brings us back to the reason why you want your terms done professionally, and you want to put in clauses like the arbitration provision and things of that sort, so that you're limiting your risks. Because if you do these things, and if somebody who's going to, trying to set a mark for one of these laws, if they look at your site and they see, you've done it right and it's very restrictive, and they look at another site where it's just a boilerplate, terms and use that doesn't really address these issues, they'll go after the other site. They're the easy mark.
Right.
As much as people don't like dealing with attorneys, this is one situation where you would be wise to, because if you can do that, you lower your risk profile compared to everybody else so much. Again, I can't promise anything 100%, but the laws are changing, and they're really going to change quickly now because we have a Republican president and both houses controlled by Republicans. So for the first time in a long time, we're looking at a period where we could see substantive laws passed on a lot of these issues that may be completely different than what we do now. What we understand
and should that happen, would you be willing to come back and give us an update so that we can better adapt to the changing times?
Sure. Absolutely.
Richard, I believe you had an offer that you wanted to make the audience?
Oh, sure. I was just going to tell people, if you have questions about the arbitration and class action waivers and you're not sure they're in your documents or it was done correctly, feel free to contact me. You can get me through my website, SoCalInternetLawyer.com, or you can just look up my name, Richard Chapo, Chapo. There aren't very many Chapos. Unfortunately, one of them is a large drug kingpin in Mexico. But no, I'm not related to him. But you can contact me.
I was going to ask you that.
Yes, no. I was very pleased when he started gaining power. I was like, really? Because I have a very odd last name. Very few people have it. It's like, really? The one person that gets it happens to be a drug kingpin. Lovely. But contact me, and I'll be happy to look at your documents for free and let you know if you have an issue or not.
And we will definitely put a link in the show notes to Richard's site. Richard, if someone wanted to connect with you, what's the best way to do that?
It would be through the site or on LinkedIn. I actually use LinkedIn quite a bit.
Okay.
So either of those are great. It's just, again, my name. You can find me pretty simply.
Well, how often do you get to hear from an attorney about what's really going on and the pitfalls, of having an online business?
Yeah.
Richard, we really appreciate your time this morning.
Thank you. It was a pleasure.
Thank you. I hope we kind of demystified some of the laws. I know it can get a little bit hairy out there, but guys, if you have questions, contact him. If you need help, I'm sure he'd be willing to help out. So, with that, Richard, thank you so much for being on the show.
It's my pleasure.
And this has been the Small Business Puzzle Podcast. I'm Teresa.
And I'm Michael.
And we're out.
You've been listening to the Small Business Puzzle Podcast. To catch all our past shows, visit sbppodcast.com.